This is Sheriff Ozzie Knezovich with the Sheriff's Report. Folks, I think you're really going to enjoy the show today. We have a guest. His name is Bob Scales, and Bob has done a lot of work for the Spokane County Sheriff's Office. He's actually done work with the Spokane Police Department and the Spokane County Prosecutor's Office. And he's done a lot of work in the area of data analysis and taking a look at our data, breaking it down, and showing what the truth behind race and law enforcement, at least in Spokane Police Department, Spokane Sheriff's Office, and the Spokane County Prosecutor's Office, it really looks like. And it's a little bit different than what the myth that is being portrayed about law enforcement and how we do our jobs, especially when it revolves around race. Bob, why don't you introduce yourself a little and talk about what you and your company, Police Strategies, do? But also, when you're doing that, uh, let's face it, our media, especially in the Spokane area, Sean Vestal and the Spokane Review reporters, always try to tear your analysis down and compare it to a professor out of EWU, Ed Burns. And the sad part about that is no one can show me any research that Ed's actually ever had published. So we have this constant dynamic of we talk with experts, and then the activist talks to their experts, because Ed Burns, Professor Ed Burns, is really an activist. He's an academic activist, and that's the sad part about it, because our society tries to rely on the old institutions to get information, but the problem is the old institutions have been co-opted, if not corrupted, by activism. So, Bob, give a little analysis of, and a little, discussion about who you are, what you do, and some of the pushback that you're actually getting.
Sure. Well, thanks for having me, Sheriff. So yes, my name is Bob Scales, and I'm the CEO of Police Strategies, LLC. I'm an attorney. I was a deputy prosecutor in King County back in the 1990s. And then I worked for 14 years for the city of Seattle. I was a public safety policy advisor to several Seattle mayors. I worked in the Seattle City Attorney's Office as the Director of Government Affairs, and I was in the City Attorney's Office when the Department of Justice came in 2011 and did their pattern of practice investigation. So I was involved representing the city and the police department in that, and that resulted in a consent decree that the Seattle Police Department's still under. And the mayor at the time appointed me to be the compliance coordinator in Seattle PD to oversee the reform process. I left the department in 2015 and formed Police Strategies with some former colleagues from Seattle PD. And our main focus is to sort of take the lessons we learned from the consent decree in Seattle, which is that no one knows anything about use of force because there is no data. And so our main sort of mission is to help law enforcement agencies collect, analyze, and report on their use of force data. And we're currently working with over 100 agencies in 8 states. And we've developed a very comprehensive data system for analyzing use of force. And the other thing that we do is we look at policing data in general. So we've analyzed data from a number of departments for including Spokane PD and Spokane County Sheriff, on everything from stops, arrests, searches, uses of force. And then recently we got a project with the Spokane County Prosecutor's Office looking at prosecution data and the demographics of individuals who are defendants in the system. And the great thing about that project is that we can tie in all of the data we've collected from Spokane PD and Spokane County Sheriff. And so we can follow people through the criminal justice system. So we can see all the decision points and where racial disparities are and where they are not.
When you give your resume, if you will, that's pretty liberal institutions that you were working for. And it just kind of makes me smile that you're being attacked by the liberal left on a constant basis when you were part of the system in those areas. And that pushback amazes me because that's all we seem to get is pushback when we actually bring the real numbers up. I get criticized, especially here locally, by our media because I use the term junk science when it comes down to the research science that they claim to, they being the activist left, claim to be using in reference to law enforcement because it's population based. And you and I, before the show, were talking how in any other research venue, you would not use this. And when I was doing my master projects and research papers, if I would have used this type of research to prove my points, I would have been I would have been severely downgraded in my reports and my research papers because it truly is junk science because population base you can make those numbers spin no matter how to fit whatever scenario you want. But when you look at hard data and you analyze the hard data, the difference between the hard data and the population based data is frightening because it shows a totally different reality. And I'm always asking my liberal friends, um, you always talk about follow the science. Well, when are you going to start following the true science on police use of force?
Yeah, well, we look at a lot. We work with a lot of academic institutions around the country, and we've published several peer-reviewed journal articles with different professors in different disciplines, including Seattle University, University of Washington, University of Texas at Dallas, and it is different looking at data from the law enforcement profession and virtually any other area that you can look at. And people tend to analyze, even academics will analyze policing data differently than they would another profession. And one of the big problems with law enforcement data, particularly for use of force, is that there is no national repository of or official government repository of use of force data. And so a lot of academics and the media will go to these crowdsourced sites for data, starting with the Washington Post or Mapping Police Violence or Fatal Encounters. And these are simply sites that collect data from media reports, mostly on officer involved shootings and that result in a death. And so they collect anywhere between 1,000 and 1,200 incidents a year. And there's no sort of quality control. We don't know how accurate that data is, but it's more substantial than anything the federal government has been collecting over the years. But then they take this very small number of incidents, and then they analyze that and look at racial disparities compared to the population. And they come up with all these, wild conclusions that are not based on science or fact or even hard, quality evidence. Basically, it's using a very limited data source of questionable quality to spin it in a way that supports your narrative of policing. And so literally we have state legislatures that are making decisions. We have local governments making decisions. We have police departments making decisions based on this flawed data and flawed analysis. And the public is generating their views of police largely from these media reports that use this flawed data. I'll just give you an example. If we compare law enforcement with law enforcement profession with the medical profession. And so one of the things I always like to talk about is, what is the third leading cause of death in the United States? And it's medical malpractice. And so every year about 250,000 people die because of some mistake that their doctor made. And with policing, we're talking about 1,000 deaths a year from officer-involved shootings. And those are not even mistakes, right? Those are 98%, more than 98% of all officer-involved shootings were found to be justified. So this is, whereas the medical malpractice, these were all 100% mistakes. So we're only talking about maybe 20 to 30 deaths a year in policing that are a result of an officer making a mistake or committing a crime, versus 250,000 deaths from medical malpractice. And yet, if you look at media reports and everything is focused on policing and the deaths caused by police. And then to compound that problem, then they look at population as the benchmark. And so they say, well, you know, if 30% of the deaths are African American and 10% of the population is African American, then African Americans are 3 times more likely than we would expect to die at the hands of police. And when you use population, you have to make a lot of unrealistic assumptions. You have to assume that everyone commits crimes at the same rate, regardless of your age, race, or gender. So kids in nursery school are committing as many crimes and the same types of crimes as people in nursing homes, as young people on the street dealing drugs. They're all committing crimes at the same rate if you use population, because they're all part of the population. And you also have to assume that the police are randomly stopping people, and everybody is equally likely to be stopped by the police. And so if you assume those 2 things are true, then maybe population would be a good benchmark. But we know that's not true. The police they cannot legally randomly stop people. They have to have reasonable suspicion or probable cause, which means that they're only stopping people where they at least have a suspicion of criminal activity. So they're not going into nursery schools and searching young children, right? And so, but the young children in the nursery school are part of the population. But so why are we using population as a benchmark? And so there are many problems, but the challenge that I have and other, you know, qualified academic researchers have is that when you publish or talk about data, law enforcement data that does not support one of these narratives that the police are biased or the police are engaged in racial profiling or discriminatory conduct, then they tend to attack the messenger rather than attacking the methodology or the data or anything and saying this is flawed. They'll attack the person delivering that message. And there have been academics who have lost their careers for publishing data, good data, that does not find racial disparities that people are expecting to find.
And that is frightening. I believe it was Minnesota, University out of Minnesota, that published a report on this topic, and their peers got together, and 950 of them got together and sent nastygrams to them. They pulled the study off, not because it was flawed, because it was totally sound. It was because it didn't fit a narrative. And when academia starts acting in this way, they lose all credibility. However, they're not losing their credibility with the media. They're not losing their credibility with the activists, but they are definitely losing their credibility with the American people. And if they're not careful, very soon they're going to find themselves in the same situation as the TV news and the newspapers of the lack of trust that the American people have in those institutions. And, you know, I caution academia, because you're supposed to be unbiased. That's what you claim, but that's not the way you're acting. And you and I share a mutual contact, a professor out in Nevada, that very liberal, extremely liberal, but is pushing back on this narrative but she will also tell you that it's not comfortable because there are risks to pushing back on this narrative right now. And let's face it, I'm going to put the elephant on, expose it totally on the table. It all revolves around race and this concept that law enforcement and criminal justice system are systemically racist. And this whole concept has led to our state Supreme Court coming out with one of the most flawed and, quite frankly, unconstitutional rulings that a Supreme Court in the United States and in any state has ever authored. And it's the Sum decision. And if you wouldn't mind walking the listeners a little through the Sum decision, because folks, you no longer have equal protection under the law in the state of Washington. They have wiped that out. And matter of fact, they have created a two-tier system of law enforcement in the state of Washington. And if you're BIPOC, you are protected more than a non-BIPOC person. And that is a harsh reality. We now have a two-tiered system in the state of Washington where we can justify very simply making a contact out on the street as long as we're not talking about a BIPOC person. If we contact a BIPOC person, the whole rules change. And, I can't wait for the legal challenges to start hitting this decision, because I've never seen anything like it. We have truly a decision that has violated and is in direct violation of the United States Constitution Equal Protection Clause.
Yeah, so that was the Washington State Supreme Court issued an opinion last month in State v. Sum, and it was in my mind, as an attorney who's practiced for more than 25 years, it was the most radical, and I say that like really radical decision I've ever seen, and a decision that was based purely on and it was a unanimous decision, but it was based purely on the 9 justices' personal opinions of law enforcement in Washington State. And it was not based at all on the facts of the case, and it was not based at all on the law or the Washington State Constitution, which is what they ruled on. Essentially, they legislated a new law that requires officers to treat people of color differently than white people. I mean, that's just the bottom line. And it is a violation of the U.S. Constitution, in my opinion. The question is how, since the justices made this decision under the Washington State Constitution, the question is how likely and how difficult will it be to appeal a ruling like this. But essentially what happened was that in the opinion, the 9 justices basically said, as a matter of law, that the criminal justice system in Washington State is biased against people of color, and that law enforcement officers routinely discriminate against people of color. And therefore, the court must take action to balance the scales and to remediate this systemic discrimination in the criminal justice system. And so the court developed it's really a new policy that judges, whenever they're dealing with a criminal case, they must take the defendant's race into consideration. And if the person is a person of color, the judge must treat the evidence differently than they would if the person was white. And it just sort of boggles my mind that they could come up with a decision like this. And they're very proud of their decision, and they're going on the media and they're saying what a great decision it is, and they're finally remedying years of systemic racism in the state.
And Bob, that's a problem, isn't it? Because that's a direct violation of their code of ethics. And more importantly, more frighteningly, not only are they going around touting this and crowing about it, they're also saying that they're looking for 10 cases to pull out and take a hard look at and overturn, which means that they've already made up their mind that that they're these 10 cases need to be overturned, and they're going to overturn them. How can you do that? Because at that point they would have to recuse themselves from this issue, because they've already shown they're biased in this issue. And who would they recuse, and who would pick that up? Oregon State Supreme Court, gets handed this thing, or what? I mean, this thing has very, very severe ramifications, quite frankly, in my opinion, for the bench, in that they're violating their code of ethics, which means that they could have a bar complaint and they should be disbarred. And they also have another issue of, if you rule on any of these things from this point on, you've already shown your bias. So how can you have this type of ruling, and how can it not be challenged? Because all an attorney would have to do is go, the Supreme Court's biased. We need to have some other court look at this.
Yeah, yeah, you raise a number of points here, and one is that Washington State, as most states do, has rules of professional conduct for attorneys, and in Washington we have judicial canons that govern the conduct of judges, including Supreme Court justices, and one of the unusual things that the Supreme Court justices have been doing, the Washington Supreme Court justices have been doing the last few months, is they've been going to the media and talking about cases that they want to overturn. And the Chief Justice of the Washington State Supreme Court was interviewed by the Seattle Times, and he said that he sent his law clerks out to look at Supreme Court opinions and to pick the opinions that they thought were racist or biased or discriminatory. And then he said that his goal as the Chief Justice is to overturn those opinions. And he said this to the Seattle Times, and there's a list of those Supreme Court opinions in the article. And basically the Chief Justice has telegraphed to all attorneys in the state, these are the cases that I want to overturn. So if you're an attorney and you're representing a client who would benefit from the Supreme Court justice overturning a particular opinion, then you're going to bring that case to the Supreme Court as quickly as possible. And basically the Supreme Court has predetermined their ruling on that case, which is a violation of all the judicial canons, to prejudge a case and then to go to the media and tell people how you're going to rule on a particular fact pattern or particular law is a violation of the judicial canons. It just is. And there's no question. But the Supreme Court of Washington State is the ultimate authority over discipline for lawyers in the state. So if a complaint was brought to them, they would have to rule essentially on their own complaint, or complain about them. And so it's unlikely that anything will happen in terms of a complaint or a violation of the rules of professional conduct or judicial canons. But that is what they have done by prejudging these cases and by going to the media and proclaiming that they are on a mission to overturn what they perceive are biased or racist cases. And they have criticized even their predecessors on the Supreme Court, saying that they wrote racist opinions, and their mission now is to correct that. And so it's just crazy. It would be like if a U.S. Supreme Court justice during their confirmation hearing said, well, my goal is to overturn Roe v. Wade. That is my goal. And it's unlikely that a justice like that would ever be confirmed to the U.S. Supreme Court. And even though when they got the case, that's what they did, but none of them went to the media and said, my goal is to overturn Roe v. Wade. So, but the Washington Supreme Court has basically said, our goal is to overturn these cases. And so bring them on. So it's like, we've talked about this before, Sheriff, but this is like being in the legal twilight zone. I mean, I have no idea what is going on because rules are not being followed. Up is down, down is up, black is white, white is black. I mean, it's I don't know. I don't understand what they're going to do next. And the case of, we can talk a little more detail about State v. Sum, but their reasoning in State v. Sum makes no sense at all, and they use very bad data, including population-based disparities, to make their decision.
Well, let's go there, Bob. Let's face it, State v. Sum. One thing, Mr. Sum was not African American; he was Asian, and Asian population base in the state of Washington roughly a little over 9%, and they account for about, if I remember the numbers correctly, 0.034% of the rest in the state. So they are very much below the utopian population base narrative that they want to use. They're not overrepresented, they're severely underrepresented. So don't know how you can get to the point where law enforcement was prejudiced against Mr. Sum based on their own arguments that Asians are severely unrepresented in the criminal justice system. However, what they did use is the Asian Pacific Islanders, and they want to claim that they're, I believe, what the number, and you can correct me when you get to it, is like 3 times more likely to be shot by a police officer than a white person, which is really junk science because and I'm just going to let you tell that one out, because it's probably one of the more frightening portions of this case, because it truly shows how the junk science of proportionality truly works. So why don't you give that aspect of it?
Sure. Well, I think it's good to look at the facts of State v. Sum, so we know what case we're talking about. And I read this case a few weeks ago, so forgive me if I get a little, not perfectly right, but this is generally what I remember happened in the case, is that you had a situation where there was an individual in a car who was sort of asleep, sort of slumped over the steering wheel. And an officer noticed that and contacted the driver, who was the defendant, Sum, and the driver or the officer said, walked at the window, woke him up, said, "Hey, how are you doing?" and everything, and the driver gave a false name, and so the officer, the individual, there was no evidence that the individual was detained. And the officer said he was basically making a social contact, trying to figure out, hey, he's asleep at the wheel. I wanted to make sure the car was parked. I want to make sure he's okay. And then, he asked for his name and gave a false name. And then the officer was going to his car to run his name. And then the driver sped off and crashed into a few things and eluded police officers, and then crashed and was caught. And it turns out he was a convicted felon, and he had a firearm in the car. So he was charged with 3 crimes: false reporting for giving the false name, felony eluding, and felon in possession of a firearm. So he was convicted of all 3 crimes. So the eluding and the possession of a firearm were both felonies, and the false reporting was a misdemeanor. Mr. Sum apparently had a long criminal history, and he's currently in prison in Oregon. So the appeal to the Washington State Supreme Court was only on the false reporting charge. The
And
defendant
that's
did.
just amazing for a misdemeanor level crime to be appealed. That generally does not happen.
Well, exactly. I mean, he has felony criminal history. He has 2 felony charges that he's convicted of, and then this misdemeanor, which means nothing, right? And the fact that the whether he had the misdemeanor or not would not impact him at all in terms of the sentence that he would do, in terms of his criminal history. It means nothing, and yet that is what the appellate attorney chose to appeal, only that charge. And there was, it was strategic, right? There was no defense, right? He had no defense to the eluding or the possession of a firearm. That was a rock solid case. So the only issue was on appeal was the suspect detained under Article 1, Section 7 of the Washington State Constitution? Was he seized at the moment the officer contacted him? And if he was seized, then the officer did not have at that point. I mean, you could argue that he did, but the court found that he did not have reasonable suspicion. I think even the officer said it was just a social contact. So obviously officers can contact anyone they want at any time and ask them whatever question they want. And as long as they're not seized and free to go, then they can have those conversations. But if you seize somebody, if you stop someone, you have to have at least reasonable suspicion that a crime has occurred in order to hold them there. So the question was there a seizure or not? And if there was a seizure, then the provision of his name is probably would be suppressed. And so the defendant was arguing that that was a seizure, and the officer was saying no, it was a social contact. So that was the key issue.
And that's the key issue that the state Supreme Court said, well, we view it differently in that because of his race, therefore, people of color have had different experiences with law enforcement, and therefore if you are BIPOC, and a person can find that you appeared to have been seized, you are now protected under the fruits of the poisonous tree doctrine.
Yeah, and it's not even appear to be seized. It's like the way the court ruled was there was really no evidence of a seizure. The officers simply contacted him, said, "Hey, how you doing? Can you give me your name? Are you okay?" And then he walked to his car. He didn't tell him you have to wait here, you're not free to leave or anything else. So factually, this was not a seizure. But what the court said was that because the officer recorded the person as Asian, that was the evidence that the court found that the suspect was Asian. And the defendant did not introduce any evidence that, oh yeah, I felt I was seized, or I was afraid of the officer, or something like that. It was just simply it was a social contact. Factually, it was a social contact.
And the harsh reality on what's happened here now is a mere social contact with a BIPOC person is, you can't really have that anymore.
Right.
If a reasonable person can can state, well, I was seized simply because a police officer talked to me. There's no more
if you're a person of color, right? So what the Supreme Court did was they basically said, okay, even though there's no evidence of a seizure, and even though it looks like factually this was a social contact, because the defendant is a person of color, we're finding that this was a seizure under the Washington State Constitution. And the reason they did that, their rationale, was that they made a finding that law enforcement in Washington state is biased against communities of color. And therefore, it would be reasonable for a person of color to feel that they were seized anytime they're contacted by law enforcement.
And the chilling effect of that's going to have on the interaction between law enforcement and the BIPOC community is amazing. And it only deepens the distrust within our society. And that truly is frightening. The more frightening aspect is the junk science that they use to justify this ruling when the Asian population is severely unrepresented in the criminal justice system, but they switch gears to the Asian Pacific, and that's how they truly justified this notion that people of color um, are, that law enforcement is racist towards them. And just describe what that one really looks like.
Yeah, so the court, I mean, literally the court said, you don't need evidence of discrimination to prove discrimination. That is what they said. And they said specifically, you do not need any data or evidence that officers in Washington state are biased in order to prove that they're biased, because we're making a ruling, we're making a finding that the police are biased. And therefore the burden shifts to the officer to show, if they contact a person of color, that they weren't biased. And the reason that I think they made this finding was because Asians are always underrepresented in law enforcement data compared to the population. They're underrepresented in stops, arrests, searches, uses of force, everything. And so you can't use the normal racial disparity analysis to show that police are biased against Asians. So basically the court said, you don't need data for this, because we're making that finding. We're finding that all police officers are biased. So that's the law. But what they did do is they pointed out that Asians, even though Asians are underrepresented, they used a statistic in the opinion, and they said, I have pulled up here and I'll quote it. They said, therefore, while some aggregated data show that Asians are less likely to be subjected to police force, individuals who are Native Hawaiians and other Pacific Islanders are 3.3 times more likely than white person to be killed by the police. And this is in Washington state. So they said that, well, even though Asians are underrepresented, there's a subset of Asians, Pacific Islanders, that are overrepresented specifically in officer-involved deaths.
And what are the true numbers behind that?
Well, the thing is that they quoted this Task Force 2.0 race in Washington's criminal justice system, which the members of the Supreme Court were on this task force. And they used data from the crowdsourcing site mappingpoliceviolence.org, which has a good database. It has a good national database. It goes back to 2013 for most states, and you can download that data. And so I looked at that data, because that's really the only place they could have gotten this statistic. So I looked at the data and I said, okay, well, how many Pacific Islanders were killed in the last 12 years? They have data going back to 2013. So in the last 12 years in Washington state, there have been 6 Pacific Islanders killed by the police, according to this mappingpoliceviolence.org.
So 6 in 12 years, one every other year. And the true catch to this is it becomes 3 times more based on the very small population of Pacific Islanders we have in the state of Washington. And again, a friend of mine once said, Ozzie, numbers never lie, but liars always use numbers. And I've never forgotten that. And this is an extreme case of that thought process. Six deaths over 12 years. All deaths are tragic. We all recognize that, but that does not show any true bias against that population whatsoever.
Right. Well, and here's how they came up with that because what they said is actually accurate. That when you're looking at the population, Pacific Islanders are 3.3 times more likely than white people to be killed. That is true. But what the numbers are looks very different, because in the last 12 years, about 600 people have been killed in Washington state by the police. 6 of those were Pacific Islanders. So 1% of all deaths in Washington state are Pacific Islanders.
And if that population mirrors what it is in Spokane, is 0.62% of the Spokane population, if I remember correctly. So you're talking a disparity of 0.42%.
Right. And then whites are a little bit underrepresented. So when you compare death rates per population for Pacific Islanders with death rates per population for whites, that's how you get the 3.3 times more likely number. And so, but of course the Supreme Court doesn't explain how they did that calculation. They just do the final number, which is shocking, right? It sounds like there are 3.3 times more Pacific Islanders killed than white people are killed.
Yes.
So you would expect to see hundreds, right? Hundreds of, but no, that's not how they do the calculation. It's very sneaky. And it comes up with this, and the way that it works is the smaller your minority population, the greater the disparities will be, because the smaller your denominator, the greater the disparity. And so because the Pacific Islander population is so small, you will always get, even with just 6 deaths in 12 years, a big disparity with whites. So it's so deceptive, so disingenuous, so misleading. And yet that is now part of this Supreme Court opinion.
Yes. Bob, we're running out of time. You and I talked about this, and I mentioned to you during our discussion that this is truly like being trapped in the Twilight Zone, where facts mean nothing anymore. Truth means nothing anymore. But we're talking about an institution, the Washington State Supreme Court, where truth should matter. But these decisions and the logic and the falsehoods that are being used to make these decisions really don't shock me, because of the history of the Washington State Supreme Court, in that I believe it was 2007-ish, they came out with a ruling that stated that lying is protected speech. And that case revolved around a campaign where one candidate defamed another, used very much falsehoods. The Supreme Court said, yeah, well, that's okay. You can lie. It's up to the public to sort that out. Well, that was pre-Facebook and all this, because I can tell you, if a candidate lies about another candidate, pretty devastating to try to unravel that. But the dissent in that case was very much spot on, that, the use of false information or falsehoods is going to undermine the very fabric of our justice system. And I believe that this is a true case of that. And as we talked, I truly believe that the Chief Justice and any justice has gone on their road tour touting this case should face a bar complaint and should be disbarred. And I take it to a step further. This is truly malfeasance in office, which makes them subject to a recall. And ladies and gentlemen, it's time to clear the bench. You need to take a hard look at who you're electing, because these people are elected to that position. Take a hard look about who you're electing to these positions, because they're no longer talking about your self-interest. They're talking about their own ideologies and their own biases, because this is truly an extreme case of bias being perpetuated by our Supreme Court. I really appreciate you coming on. Any parting words of wisdom for the audience?
Well, I don't know if it's words of wisdom, but you mentioned it earlier, Sheriff, about the impacts that this case, this Supreme Court case, will have on law enforcement, and that is one of my biggest concerns, is that this case will dramatically impact public safety in Washington State, and the communities that are going to be impacted the most are communities of color. Because what the Supreme Court has done has said, we do not want law enforcement to engage with communities of color.
Yes.
They have exposed individual officers to complaints and lawsuits, departments to risk and liability, because police officers now must treat people of color differently than white people, and there is a disincentive for officers to engage with communities of color because there are additional risks that they now have. They can't just walk up to a person of color and say, "Hi, how are you?" Or if they see somebody in distress, they run a risk, if it's a person of color, contacting them, because even if they're not detaining them or arresting them, that person can still claim that they were seized by that officer because they were a person of color. And that is a real risk that officers now face and departments now face. So I don't know what the impacts are going to be, but I know there are going to be more complaints, there are going to be more lawsuits, there's going to be more liability, and there's likely going to be disengagement from communities of color because the Supreme Court has said that law enforcement's biased, and so stay away from people of color. I don't think that this case has gotten enough attention from elected officials and from the media. And the problem is that because the Supreme Court used the Washington State Constitution as the basis for this decision, there's very little, I think, legislatively that can change it. I think we're stuck with it. And so now we just have to see what the impacts are going to be. So unfortunately, it's not, I'm not very optimistic about where we're headed.
Yeah, I'll take it to another extreme, because those who commit crimes, I've found, they're not dumb people. They really aren't. Contrary to the stereotypical aspects that some people want to assign people that commit crimes, they're they're very smart people, and they learn very quickly. And on the other side of that argument, all it takes now is a white suspect to go, well, you're only focusing on white people now in your enforcement efforts because you're you can't talk with people of color, therefore you're biased against me, and I can't wait to see that complaint. Because and folks, if you think I'm being outlandish on that statement, I'm not. I've 32 years of doing this job. I know what's coming, and I know that's going to be an argument that's going to be made that the Supreme Court has created this two-tier system, and anytime you have that, both tiers can make the same claim, and I see that happening on both sides. Law enforcement is going to be caught in a direct middle of that, and our job. This was basically a welfare check. Mr. Sum was basically a welfare check.
Yep.
Individual slumped over their steering wheel. We go check that to make sure it's not a medical issue or anything else. And now, based on color, if it's white individual, I guess that's okay. If it's a BIPOC person, that's not so much okay.
Leave
But
them
if
alone,
that,
right? The
yeah,
Supreme Court doesn't want police officers to contact people of color that unless you have basically probable cause
right.
for a crime, the Washington Supreme Court does not want law enforcement contacting people of color. That is their message.
And I can see all kinds of liability in that. Well, you didn't make contact and this person died because they were having a
Yep.
medical uh, situation, or if they're white and they're a criminal and they're slumped over because they're passed out due to their drugs or alcohol. Well, okay, this is racist and biased because you don't contact anybody else but us. That I can see these outlandish type of cases coming because let's face it, defense attorneys make money by suing, and you know many times eh, organizations are forced to settle these type of claims because the cost of
Yep.
litigating them are prohibitive based on the squeeze isn't worth the juice.
This case is
So
going to cost hundreds of millions of dollars to local governments, no
yes,
question.
Bob, I really appreciate you coming on. Look forward to having you on more often because I think that you bring an insight, and I think that we need to to really have these open discussions that, quite frankly, very few activists really want to have, even though they claim they want to have them. They only want to have them if they're in a safe environment. Case in point, here in the city of Spokane, we have a kind of a task force little group that the mayor put together, and the city council president, where all the people of color and law enforcement and people in the criminal justice system meet. But you know what? In order to be part of that group, you have to sign a waiver of non-disclosure. You're not going to disclose what happened in these meetings, and that is so far removed from what this nation truly is all about. Transparency. They talk transparency all the time, but when, in these meetings, the people, the BIPOC community wants non-disclosure of what's said. Well, I've always said, anytime you want to have an open, honest conversation, let's go for it. Bob, I appreciate it. Thank you very much. Have a good day. Folks, this is Sheriff Ozzie Knezovich with the Sheriff's Report. Have a great rest of your day, and have a great summer. We'll talk to you later.